Hey everybody, Ben from Lawyer's Guide. Kirk and I recorded an episode on Monday, March 1st, 2021 about net neutrality, and although it was a very fun episode and we spent probably far too long talking about it, unfortunately we had some technical challenges and not all of the content that we discussed made its way onto my hard drive. So I had to do some creative editing to cut around some areas where Kirk cut out or I cut out, so you may notice some odd cuts and hiccups. Apologize for that. Please just indulge us if you would during this ongoing pandemic as we wrestle with the reality of having to record remotely in different locations. So hopefully you enjoy it and look forward to continuing to bring you more content for the rest of the year. Thanks.
Welcome to A Lawyer's Guide to the Galaxy, a podcast about geek culture by lawyers with your hosts, Ben Siders and Kirk Damon.
And welcome back to A Lawyer's Guide to the Galaxy, the podcast that asks interesting questions that don't have any answers, with your host, Ben Siders. That's me. And the other guy is, as always, Kirk Damon.
That's Kirk, as in the captain of the Enterprise.
We are intellectual property lawyers and certified geeks practicing law in St. Louis, Missouri. You can find me, Ben, on Twitter at Benjamin Siders. You can find Kirk at KirkDMN. And you can follow this podcast on Twitter at LGGPod. We also have a website, lggpodcast.com, that will direct you to the various platforms where you can find, subscribe, and download prior episodes. So we are back. We are season 4, episode 3, I think we're on now.
That sounds about right.
And we are going to
I've lost track.
At long last take a crack at a topic that we've been threatening to discuss since the outset of the podcast, basically. Actually, I think we launched in 2017, and one of the first things that happened is that they repealed the net neutrality regulations, which very much angered a lot of people. So we're gonna have a discussion about that. This is going to be an unusual episode for us because net neutrality is an issue that I think, Kirk, I don't want to speak for you, so jump in, but I think both you and I generally favor the ideas behind net neutrality, but you and I are both always the devil is in the details kind of guys, and the details here are voluminous.
Yeah, and I think that's going to get to what we're going to talk about this. I'm going to tell you just sort of to start off with, this is not my area of expertise. Ben is much more knowledgeable about this than I am, having studied these regulations and stuff much more than I have. I come at it from having actually worked quite a bit with cell phones and cell phone technology and stuff related to more telecommunications, which obviously underlies some stuff related to the internet. But it's one of those where I think both of us kind of look at it and say, yes, we do favor generally net neutrality, but that leads us to the first point, which is what do we favor? Because what is it? Neutrality?
Yeah, it's a deep, dense topic. There's a lot of history behind it, and a lot of it revolves around the idea of something called a common carrier, which we're going to discuss later on in the podcast. We'll probably at some point do a more detailed episode on that. But for now, we're going to try and stick with really the last, I'm going to cover maybe the last century of history here or in like 60 seconds. We're going to really stick to what has gone on over the last maybe 20 years, 30 years, basically our adult lifetimes, and how the internet is regulated in the United States, how it's not regulated, which is probably a more accurate way to describe it. But to start with, when we talk about net neutrality, you have to start by figuring out what exactly it is you mean, because there's net neutrality and then there's net neutrality, and then there's also net neutrality.
Yeah, and there's also neutrality on the net.
I to prepare for this, I started with the Wikipedia definition. I'm just going to read it to you. So here we go. Network neutrality, most commonly called net neutrality, is the principle that internet service providers (ISPs) must treat all internet communications equally and not discriminate or charge differently based on user, content, website, platform, application, type of equipment, source address, destination address, or method of communication. End quote. The key words I want to point out there is must treat all communication equally.
Another key word there is ISP.
Yes, for ISPs. This is a broad definition, and I'm going to say something that if you're a net neutrality fan, you're going to argue with me when I'm done, so be prepared to get triggered. I've yet to meet a single person who believes in this, not one. And I know what you're thinking, listener. You're thinking, well, I'm one. I'm going to email you, Ben, and I'm going to tell you how wrong you are. So you're telling me that, I'm a surgeon doing a live telemedicine procedure in consultation with the world's foremost expert on that procedure. He's in Singapore. I'm in New York. But my traffic for my teleconference cannot be given a higher priority over somebody playing Fortnite or watching The Office. Okay?
The real key here word, and I think that what Ben's picking on is the word must.
Must. Yeah.
And let's talk about this just briefly. And it's one of the things I want to sort of get into because, for those of you who know, we're both patent attorneys. I work in conjunction with patents. And when I train younger associates, one of the key things I tell them is ban the word must from your vocabulary, because must means 100% of the time. Yeah, it does not mean 99.9. It means 100% of the time. That means if you're looking at what this statement says, that you must treat all things equally, it means there can be nothing with priority ever.
Yeah, which is obviously not what anybody really wants. I would rewrite this maybe to start with as saying should. ISP should not discriminate. And then add to that without a good reason. And what is a good reason is a function of sort of our collective social attitudes about how the internet should work. And that probably hews closer to what net neutrality advocates really want. I should say up front, Kirk and I both generally favor these principles. Neither one of us, I don't think, has a real big dog in this hunt. I didn't feel especially strongly about adding the net neutrality regulations when we did. I didn't feel especially strongly about removing them when they were taken away. And so then I went out trying to find articles that would kind of lay out the legal background in a neutral way. And what I discovered was when it comes to net neutrality, I could not find anywhere a single article that got into any kind of, not even detail, but just a basic overview of what the operating legal principles are that was not written by somebody with an obvious, unhidden axe to grind, generally in favor of net neutrality. The closest I found was a woman who wrote for, I think, Engadget. And I'll see if I can find that article and link it in my notes. Even she had an axe to grind, but she at least laid out the law, I thought, pretty well. That's what got me into digging into this and me wanting to lay out a description of what this is.
One of the things I think to get into with this, and I think it's worth pointing out, sort of at this point in time, is we are dealing a little bit in conjunction with net neutrality with what is arguably a politically charged topic. There are people who are
definitely politically
on both sides. It definitely is now. It arguably used to be. I don't think nearly as much as it is now, but I think you have stuff now. One of the things you tend to bump into, and this is just a general thing as a lawyer you encounter, when you start talking about any kind of law which has any kind of political charge to it, one of the things you bump in very quickly is that a lot of discussion of it doesn't actually relate to the underlying law. When you talk to people who are, you can say, hey, what does this case actually say? And you'd say a case which, can be the basis of anything which is sort of politically charged law. Very few people actually know what it says. And part of the reason is because a lot of cases are not decisions necessarily on the merits. They're not necessarily sort of statements as to what it is. So an example would be, is a lot of people would look at it and say, oh, this law said, this case said X is legal or illegal or whatever you want to look at. And the answer was no. They did the opposite. They failed to make something that was legal illegal. It didn't say it was legal.
Right? Everybody likes to cite the 2 Live Crew case for the proposition that the Supreme Court has said that satire is fair use. That's not what they said. They said it isn't not fair use as a matter of law. That means there are facts where it could be fair use. There are also facts where it might not.
The reason I bring this up is because in law, it's very important to recognize that a double negative is different from an affirmative. Those things have 2 different meanings. And the example, the one that I always use in conjunction with it, is not guilty does not mean innocent.
Correct.
It's what it is.
Failure of the prosecution to carry its burden of proof.
It means you had to find out whether or not you tried to find out if the person was guilty, and the answer was you failed to prove they were guilty, therefore they are not guilty. It doesn't show that they are innocent. Innocent means they actually didn't do it. Yeah. It simply means that they were not proven to be guilty. And the reason I raise this, and the reason I'm sort of bringing this up in a general sort of calculation of it, is that's a little bit what we want to get into in conjunction with this episode, is sort of point out the things that here's the background of what this is coming from. This is an extremely complicated issue because we're talking about laws that have to do with the regulation of essentially communication of common carriers, of public goods, sort of things like that. There's a lot of laws here. When we look at this, it's not something that we necessarily can look at and say, this is one law. There's a lot of pieces behind this. There's a lot of things behind this.
And a lot of history too that goes along with it. We're going to summarize a little bit of that, but it's you can't fully understand it without knowing at least a little bit about how we got it. What people are really worried about is that the internet's going to become like how your cable subscription works, where, I have to pay an extra $45 a month for the social media package, or they'll cut off my access to Facebook and Twitter. I look at it as what I call the unramped compact. When we go out and buy an ISP, internet services, we are looking at our ISP as the last mile solution. They've got a wire that runs to my house.
I connect my computers to it, and over that wire, I send and receive electrons that turn into data. And that's all I want. And we don't want the ISP interfering with our regular use and our discretion on how we use that, provided we're not doing anything wrong. And I don't think most people would disagree that there are certain higher priority types of uses or users that should receive priority. It's probably less of an issue now because there are separate private networks that high priority users can use. But just in principle, I don't think most people would disagree that there are at least some classifications that are more important than your World of Warcraft game. So with that background, when we talk about net neutrality, I think we're mostly talking about the unramped compact. Once I pay you for my access, I get to decide within the bounds of the law and reason what I'm going to go do, and the internet service provider is not going to interfere. Crafting a set of public regulations that achieve this, though, is tricky. I don't think any country in the world really has a good set of them yet. There's been a lot of attempts at dealing with this. A lot of countries have different metering and billing practices than what we have, so their rules address different concerns. But getting your arms around this, there's just a lot of misinformation about what not only what net neutrality is, but what the laws really are.
I think a good way to think about this, and I think it's worth noting, one of the things you commented about is the fear for net non-neutrality, so to speak, comes out of cable TV, and particularly the way cable TV is provided. And, when you talk about, and I think it's a good, valuable thing right now, people talk a lot about now about, cutting the cable, going to, streaming services, stuff like that. Cable TV for a long period of time, and pretty much still now, where if you want cable TV, you have to buy a package. You cannot just get access to cable TV and watch what you want. You get specific stations. Those stations are packaged, and that's decided by your cable provider what comes in each individual package.
And negotiate with the various content providers over what's going to be included and at what price.
Yep. And they can cut you off. I mean, we've all encountered it where it's hey, you suddenly can't watch the, local sports game because that station is cut out of your cable because of a dispute with that station. This is what people are worried about, in some sense, that are worried about net non-neutrality.
We do need to kind of step back and give you just 60 seconds on where this all came from. And I've teased this a little bit in some prior episodes where I mentioned that the sinking of the Titanic tells you what you don't know about net neutrality. So I'm going to finally explain what I mean by that. We have to deal with this concept of the common carrier. And, the nation did not initially regulate a lot of this type of infrastructure all that closely until the Titanic disaster. There were some very tepid baby steps into regulation, but, in part of the investigation of the Titanic disaster, they had wireless radio on the Titanic. When it got close enough to shore, they could contact shore stations and they could get updates. They could also get wireless updates from other vessels. And over the course of the evening before the vessel sank, the radio was operated by the radio company, not by the ship, the Marconi radio company. They were receiving two types of messages. Well, probably more than that, but two that we care about. One is messages sent by people on shore to passengers on the ship. Commercial communications. These are the things Marconi was making money off of doing, and that's why they were there. The other kind of communications they got were things like weather updates, ice sightings from nearby vessels, things that are boring and not interesting when you're trying to make money off of your radio. So if you're sitting there in the early 1900s and wondering, gee, which message is going to get priority? It's the one I'm being paid to deliver quickly, not the boring update about how cold it is in the North Atlantic. Yeah, we know. We're there. We can tell. So that was one of the sort of indictments of how things went wrong, is that ships were sending out wireless warnings of all kinds of icebergs that they've sighted. And I think it's even believed that the iceberg that hit the Titanic was sighted by another vessel in its path. Those messages did not get to the bridge promptly because Marconi was discriminating in favor of stuff that it made money off of.
And the reason I say this tells us a lot about net neutrality is you might be thinking, yeah, perfect, so we need net neutrality. No. No.
That was net neutrality.
No, that was the wrong neutrality. The ICE messages should have been prioritized, right? We should have had a public policy that things that pertain to public safety and the welfare of the passengers get priority first, over everything else. So it's still not net neutrality. It's just going the other way, the way that makes more sense. So, we then had the Radio Act of 1912, which regulated radio and seafaring vessels. That morphed into the Radio Act of 1927, which strengthened federal licensing and control over terrestrial radio. But the current regime was enacted in 1934. Some of the New Deal legislation, the Communications Act was passed, which brought the control of wired transmissions, telephone, telegram. That was under the Interstate Commerce Commission. I think it got moved from there to
the new agency, the Federal Communication Commission, along with wireless. So radio and wired, phone and radio both got moved to this new FCC.
One thing to keep in mind, there's also a lot of other things going on at this point in time which relate to these types of things. So perfect examples of what it is, extremely powerful radio stations.
Yes.
Existed at this point in time, ones that could broadcast pretty much through the entire United States.
Yeah, we have frequency conflicts and things like that too.
So it's not, when we're talking about sort of these kind of things, that we're not getting into this regulation just because of sort of the Titanic and ship to shore communications. We have wireless exploding. We have wired communication exploding. And because of that, we're getting a lot of potentially problematic things happening around it.
So over the years, the FCC's jurisdiction has expanded. They cover radio, television, cable, transmissions, wire, satellite, et cetera. But one of the things that's not on that list is internet, because internet is weird. You can get internet over radio. You can get internet over satellite. You can get internet over cable. So we have an agency that's regulating the transmission medium itself, but it's less clear whether they can regulate the things that are transmitted on them. So if you think of like a traditional modem, your computer literally dials a phone number. It picks up the quote unquote phone and it makes a call to another computer that answers the quote unquote phone. And the phone company has no idea what you're doing. They don't know whether, just a bunch of analog data on a line. They have no clue. So that's not really their concern, whether it's voice, whether it's analog or whatever. But, why does this all matter? Well, the reason is because the Communications Act that governs all this stuff has a number of different titles, which is just a fancy way of saying how we've organized things that the agency can do. But the probably the broadest grant of regulatory authority is in Title II, which applies to something called a common carrier. Kirk, have you heard of a common carrier?
I have heard of a common carrier.
Yeah. So this is a very old legal term that I want to say originates from like Renaissance, merchant fairs and trade fairs, but basically, it's anytime that you have, not anytime, but it's when you have somebody who's using public infrastructure to transport people or goods, which sounds like a broad category, and it is.
Keep in mind, this covers things like horse carts.
Yes, that's all where it came from, was that era. So passenger trains, airlines, cruise ships, ferries, taxis, anything like that that's moving people around. The law has for a long time, well before the United States, imposed heightened standards of behavior and safety and heightened duties upon common carriers. It
isn't just people, it's also goods.
Yeah,
and that's the other thing to keep in mind in conjunction with this. When you provide, a package to be, or you buy something off of, your favorite website and it's shipped to you via a shipping service, those are common carriers. They are carrying stuff which is yours. And they're carrying stuff which belongs to many people. So that's part of the start of this, is we're looking at it and we're saying this radio infrastructure, this wireless infrastructure is carrying stuff which is yours, which is information, for lack of a better term, communication. And when we're talking about common carriers in this, and I think it's an important piece that you glossed over just a little bit there. Let's go back to the dawn of the internet. The internet infrastructure and what was used was existing telecommunication infrastructure, at least to start off with. So when you talk about what is, going across a telecommunication line, an internet communication, somebody downloading a picture over their modem was using the same line as somebody talking on the phone. So when we look at the idea of, say, and now we're looking at, what are these neutral communications? We can look at it and say, well, what's being transmitted is bits of information. The answer is this is all data, either analog or digital, depending on exactly where we want to look at it. It's all traveling along these various lines. Some of it is voice, some of it is data coming from a computer. But these things, as far as, a trunk line operator, and a trunk is the large lines that interconnect major cities like inside the United States and around the world. The trunk line operator doesn't really know what the data is. They don't know if it's a phone call to your mom. They don't know if it's a 911 emergency call. They don't know if it's, your computer downloading something or what it's
and doesn't really care. Their job is to maintain the infrastructure. There's the wire connected from A to B, and is the transmission getting through? And if it is, then that's their job. They're dealing with the transmission aspects.
Yeah, and that's what we're sort of dealing. That's what we're starting with in this, is when we're looking at the idea of saying the internet didn't create its new infrastructure. Now we're talking about like the creation of Marconi and the radio. We're talking about a lot of sort of the AT&T setups. We do have a creation of an infrastructure as well as part of this, which doesn't exist in conjunction with the internet.
And that gets into the difference between a common carrier and a private carrier. A common carrier holds itself out to the general public for business. And it can't usually discriminate about who it takes on, who it does business with, because it's operating for the public necessity. So, broadly speaking, the government has, more authority, both moral and legal, to impose restrictions on common carriers and regulate them because they're conducting commerce using natural monopolies that are owned by we the people. They're our roads. They're our rivers, they're our skies, it's our air. And to the extent that we let them put wires in the ground, it's in easements next to our roads and everything else. So, the common carriers are thus highly regulated and have been for a long time and have all these heightened duties, even under common law, torts and things like that. That's to be distinguished from private carriers who contract privately only for specific clients of their choosing. They can refuse to take on specific people or specific goods for basically any reason. Good example of that is a private airplane. So
now we get into the question, is Amazon Prime Delivery a common carrier or is it a private carrier? The U.S. Mail Service is a common carrier, but it's also the U.S. government. So you have sort of some uniqueness in that. So these are the kind of things where you get into these kind of questions. This is what we said.
Amazon only delivers Amazon packages, whereas FedEx can deliver Amazon packages or Walmart packages or anything else. Think of it like a taxi. Like the taxi just pulls up and accepts whoever wants a taxi, and they don't really they have some discretion, but not much to refuse to take you someplace. Under the Communications Act, these common carrier services, they also can't pick and choose customers, and they also can't discriminate. And all the rules that regulate this are in Title II of the Communications Act, which is why Title II is so important. It gives the FCC the most authority and discretion. So a long time ago, the question arose of, well, what do you do with things that are more than mere transmissions, but which use these channels of commerce or communication? And we're talking back, this is like the 60s. This is like the AT&T monopoly days, which I'm sure most people listening to this podcast probably don't remember. I don't remember.
Well, we don't remember, quite frankly.
Oh, we know more about them. Like we grew up in a time not that far removed from them. But there was a time when you had to buy your phone from the phone company, to hook it up to the network. And but third parties had begun to sell equipment that you could plug into the AT&T phone network. And you could do other things. You could do computer processing and things of that nature. So this, the FCC had to figure out, well, do we have any authority to get involved in that and set rules about who has to be allowed to plug in which devices on these endpoints? The FCC at the time drew a line between what they called basic services and enhanced services. And enhanced services is what we now think of as the internet. Basic services, they said, is pure transmission. It's the stuff that they've always been doing. Just pure transmission, point to point, regulating radio, regulating wire, regulating whatever. Congress delegated authority to the FCC to regulate in that area. That was where they had a clear permission or grant of authority to do that. So for basic transmission services, yes, the FCC can regulate. But for enhanced services, they said no. And they said an enhanced service is anything beyond mere transmission over one of these channels. They said, we're not going to regulate there, which left, practically speaking, that aspect of communication unregulated at the federal level, except maybe by the Federal Trade Commission, which is our federal consumer protection branch. So this happened in the 1960s. It was revisited in the early 80s. The FCC reaffirmed, we're not going to touch information services. When they broke up AT&T into the baby bells, they did it then as well. They said all the local operating companies are going to be CLECs. Local exchange carriers, but ne'er into information services shall you step. This dichotomy was entrenched early on, and then not much changed until the mid-90s when the internet became a thing, and we finally had a new telecommunications law for the first time in 60 years at that point. It had been a while. The Telecommunications Act of 1996. Congress at the time kind of took the attitude of, this internet thing is new. We don't really get it, but it seems to be working really well. And the economy is growing. We like that. People are excited about it. We like that. And it's all happened without us getting involved. So why don't we keep not getting involved?
And I think it's important to point out, in 1996, think about where the internet was. For those of you who just go back and like one of the machines on the internet and look at where the internet was. We have no Google. We have no Netflix. Mm-hmm. We have none of the major things you think of as using the internet in 1996. In 1996, the web was really pretty new. This is something where, the internet at that point in time was a lot of text. We're not talking about the internet we have today. The internet we have today is very different than the internet was in 1996. And for anybody who's, listening to this that isn't familiar with that, that grew up with universal broadband and stuff like that.
Telecommunications Act of 96 was basically the state of play until, the late 2000s, early 2010s. And it was not until then that the FCC actually promulgated anything that could be called like a net neutrality regulation or requirement. They had published a lot of what I would call expectations or suggestions for how they wanted things to work, but internet services were still not classified as common carrier services under Title II. And so they were not subject to those greater regulations. At the time, you start to see some instances of the sort of things that net neutrality advocates were afraid of starting to happen. Things like ISPs slowing down traffic for certain types of services like BitTorrent. From the regulatory perspective, it's not really unlawful to do that. You could argue maybe that there's a consumer fraud, consumer misrepresentation going on there, that you're not being told that when you buy the service, certain websites are going to be slower than others for reasons that have nothing to do with the website. It's about the separate commercial arrangements of your ISP. I think that violates the Unramp Compact. And I think, Kirk, both you and I would say that's the kind of thing we don't want our ISPs to be doing.
I think that's correct. And you definitely don't want this sort of internal collusion with the idea that we're going to rank one private content provider over another private content provider. The other thing I think we also saw at this time, not only was, the potential concerns about that, but we have for the first time extremely large content starting to go across the internet relative to the infrastructure that was created. I mean, there were days back when the limitation on what you could download was your modem speed. Downloading a single large image took hours. Mm-hmm. What we now have going in at the time of this is happening for the first time, we have things like streaming video, which compared to, again, what the internet had been not 10 years earlier, was enormous amounts of data, comparatively. And the part of the real concern, I think, with it was this is bogging down the internet, because while these carriers may not have necessarily any, there may not necessarily be any preference form or whatever it is, they by definition sort of have to have preference, because they grab a line and then they start transmitting these huge amounts of data across it. And I think that's also part of what goes in there. So you have that idea that you're looking at, for the first time, we have very large amounts of data being transmitted. We have the possibility of carriers and ISPs looking at it and saying, we're going to make a decision as to which of these large things we're going to prefer, and we're going to make that decision based on who pays us the most amount of money.
Yeah, and we should say, to this point, the general investment in the internet infrastructure had basically kept pace with the changes in technology and the user demands. We saw consistent increases in bandwidth. I remember the first time I had megabit internet. Oh my gosh, that was such a big deal. Megabit. I mean, how could you ever need more than that? Now I just got gigabits the other day. So, the infrastructure largely kept up, not uniformly across the country, but for the most part, the investment was there. It's not cheap. It's a lot of work to do. There's the last mile problem is always there. How do you get to how you get the wires to the individual houses, because then you got to go back and rewire everything, unless you can just introduce like a new standard or something like DOCSIS 3 or DOCSIS 4, something like that.
That's an important thing I think to keep in mind here too, is there's two ways to speed up the internet. One of which is to literally go out and dig up the lines and put bigger ones in. Mm-hmm. That's incredibly expensive. And you have to keep in mind that the sheer cost of doing that is enormous. A lot of the speed benefits which are gained is data compression and essentially software solutions where a line can simply carry more data. One of the things, if you would all get into sort of speed and internet speed, I can tell you my fascination with the network was always what they call the physical layer, the literal wires and how the wires do what they do. And it's one of those things where when you get into those types of things, there becomes an upper limit on what a wire can carry. We are very, very good at cramming data onto those lines compared to what we used to be able to do. But there is upper limits. There starts to reach the points where literally quantum physics starts to say you have problems. And that's an important thing to keep in mind, is you've got these sort of double boosts, but a lot of it early on was not necessarily physical infrastructure going in the ground. It was figuring out ways to make them the lines exist faster.
This is also part of the backdrop of the net neutrality debate, and the part that I know the least about. I know that in the discussion leading up to the 2015 Open Internet Order, which we'll cover in a second, and the repeal, there's a lot of discussion about how the net neutrality rules will impact the incentives for telecommunications companies to continue to invest in the infrastructure and expand our capability. In 2015, the FCC for the first time, effectively reclassified internet as a common carrier service subject to regulation under Title II. That finally gives them this broader authority to impose regulations and to deal with things like discrimination, access, things of that nature, the same kind of rights and authorities that they had to regulate transmission, make sure everybody has the same kind of access. So that happened in April of 2015. And I believe they did promulgate regulations because I have read them at some point. It was about 3 years ago. The regulations were lukewarm, as I recall them, effectively being what Kirk and I just discussed. They looked nothing like the Wikipedia definition of net neutrality, where you must not discriminate.
We're talking common carriers. Remember, the Mississippi River, in some sense, is like the underlying trunk line, in the way that we're talking about common carriers. So it is one of those things to sort of keep in mind. What we're dealing with here is a real difficulty of figuring this out. The other thing to keep in mind in 2015 is we now really kind of have the start of the internet that we're used to. Now, that internet's created by a bunch of startups in the sort of early, late 90s, early 2000s. So we had the tech bubble in 99. We sort of had those kind of things sort of carry into the beginning, but a lot of what we now think about, these major behemoths on the internet, social media, Facebook at the point in time, Yahoo, Google, these large sort of behemoths coming in whose in some sense exist because there wasn't regulation. They were able to look at it and come in and say, hey, we can transmit this. Netflix moves from I'm supplying DVDs to customers, via these kiosks and gas stations to I'm supplying content streaming over the internet.
The rules they proposed were, I liked them. I didn't think that they changed a ton though. So here's the first one. If you're a broadband internet service provider, you cannot block lawful content, applications, services, or non-harmful devices subject to reasonable network management. And all these rules are subject to reasonable network management, which means you may, and there's a whole separate provision that covers the conditions, but basically based on how much bandwidth you had and what your resources are, you can cut people off if you want to in the purpose of network management. If you got one person who's hogging all your resources and killing off all your other customers because you don't have that much trunk space to go through, you can shut them off. It's fine. So,
how many of us are familiar with throttling? The phrase throttling. You're entitled to stop people from screwing up the use of the infrastructure. They can't completely hog the road. In effect, they're saying you can't send a barge down the Mississippi River, which takes up the entire river. We're fine with that. And you kind of look at it and say, yeah, that's appropriate. That's something that they should be doing.
Shall not block lawful content. I think we'd all agree with that. Can't block lawful application services or non-harmful devices. It all sounds very reasonable on its face. Here's the thing, though.
What's a harmful device?
Yeah.
But what does it mean to say that the device on my network is harmful in some way? Presumably, the FCC will decide, or they would have decided, had this stayed the law. What is lawful content? What is a non-harmful device? Things of that nature, and then subject to reasonable network management. That's kind of a squishy standard. The next rule says that you cannot impair or degrade lawful traffic on the basis of the content, application, or service subject to reasonable network management.
Yeah.
There's your throttling rule, right? I can throttle you all I want in the defense of network management.
Yep. But I can't throttle, for example, you downloading a movie versus you playing an MMO game. Because that's based on the content, not based upon reasonable network management, if they both take the same amount of space. And I think that's what they're trying to say here is, hey, you can't make it content based. You can't say certain types of content have priority over other types of content, but you can look at it and say your content is just simply too big. Mm-hmm. I think the problem you get into with that is we say, if we're looking at saying what's too big is reasonable network management, well, one could be downloading a Netflix movie. The other could be performing video surgery. Those are both gigantic files. Mm-hmm. Now you look at it and say, hey, we've got both these things carrying across. Is it reasonable network management or is that content? And we kind of start looking at it and saying, well, wait, we do kind of want to regulate content, don't we?
And the last one I've got here, a person engaged in the provision of broadband internet access service shall not engage in paid prioritization. And paid prioritization is the management of your network to favor some traffic over other through the use of various technological techniques. But here's the thing. It's only a paid prioritization if it is either in exchange for money from a third party or to benefit one of your affiliates, which means they can still prioritize whatever traffic they want over other traffic. They just can't take money for it.
And this is where I think we kind of get in, quite frankly, this is the piece that's trying to get at that original problem of the cable bundling package. The cable bundling package is entirely monetary. I think there's no question that stations are included based upon, payments and discussions like that. That's what this is saying. This is looking at it and saying, hey, you can't say this company can pay you to hog the trunk line, to hog the space as to what it is. Versus somebody who won't pay you with it. Now, you can still let them do it. You're just not allowed to take money in exchange for doing it. And the real thing here is that, again, and that's the reason I harped on that just a little bit, coming out of cable TV and the concerns with that, I think that's the piece of the regulation we see playing with this. We see this idea of saying, hey, you can't do those kind of backroom deals. We need to have, sort of whatever it is. And really those deals can't be for money. Now they can be arguably for something else,
Well, it does say consideration. So they were careful with how they wrote it. So
yeah, yeah. And it's, but again, when you look at it and say, what is consideration, in conjunction with it, one can look at it and say, I'm going to prioritize based on the reputation of the underlying company. What does that mean? Well, I'm not gaining any beneficiation for that. I'm not getting any consideration, but at the same time, that arguably is discriminatory in how I'm choosing it. I'm choosing more famous companies over less famous companies, but those kind of things are potentially allowed. Same as I could say, I'm going to request one that has an increased demand over ones that have a decreased demand, for simply my services. But again, what they're really trying to prevent here is the deals that say you get pay for play access.
Yep.
I'm taking a gaming term, obviously, but
yep. What is reasonable network management? A network management practice is reasonable if it is primarily used for and tailored to achieve a legitimate network management purpose, taking into account the particular network architecture and technology of the broadband internet access service. So that's a lot of ways to say, does it pass the smell test, basically?
Yeah.
Does it look like you're really managing a network, or are you trying to game the system?
Yeah. And again, there's nothing wrong in some respects. And this is commented a lot of times. A lot of laws are written sometimes with, amorphous terms in them on purpose.
Oh, yeah.
So that judges have discretion in their interpretation.
Yeah, you want to have some flexibility, right? To apply them to specific situations and not be too hemmed in by the language. So, to be clear, overall, these are all good things. I'm fine with all these rules. I don't think they go anywhere near as far as sort of the popular perception of them is. They call these the no blocking, no throttling, no interference rules. Well, it's not really no blocking. It's conditional blocking, conditional throttling. It's still permitted under certain circumstances. And this is where I think the language of technology and law all kind of gets mixed up. It makes it hard to talk about. You get mixed up between, this is why we started off with, what do you mean by net neutrality? Do you mean the Wikipedia definition, must not ever? Because that's not what the laws were, and that's not what the laws are anywhere. Like that's not workable. So, what you have here, I think is a reasonable framework. I don't think it really changes much. It does clearly prohibit some practices that I'm happy to see prohibited. But these were proposed rules. I forget when exactly they were enacted, but the bottom line is the authority to enforce was moved from the FCC back to the FTC, the Federal Trade Commission, in 2017 when they reversed this classification and took internet services back out of title.
It's simply that the agency that has the authority to enforce has moved. But I think a lot of people, when they saw this, were very concerned about the enforcement.
Yeah, and so when it first came out, that was what was supposed to happen. Subsequently, I believe there was an order by a court shortly after that held that the FTC does not have authority to enforce the FCC's regulations.
Correct.
I think part of the concern with the FTC doing it is that the FCC has historically been one of our more aggressive regulatory bodies. People had a lot of confidence in them really taking the initiative and really enforcing these things rigorously. The FTC is a little more, I would use the word judicious, although that's probably a loaded term. But I would say less aggressive, certainly, in when they decide to get involved. But, the FTC is the main organization that deals with enforcing privacy regulations now. And they've been, I think, reasonably aggressive about that. So I think maybe the tone and attitude at the FTC is changing. So I don't know if the FTC is doing a decent job or if it's just not hasn't been enough time yet to really see any negative consequences of repealing these rules. So there's sort of an open question there. And I know that there have been legislative attempts to reinstate the rules. And I want to say, so we're in, if you're listening to this later, we're recording this on March 1st of 2021. Joe Biden was recently inaugurated as the next president of the United States. So, there's and Ajit Pai, who was the chairman who oversaw the repeal, has now, I think, rotated off the FCC. So there may be some change coming there. There may be a switch back to these net neutrality rules. It'll be interesting to see if there's any practical consequences. So if any of you work in an ISP or network industry or another kind of industry where you have seen the consequences either of having the rules from 2015 to 2017 or not having them since, let us know, because I think we want to do a follow-up episode to dig into sort of the practical side of this more and kind of find out, how has it worked in practice? How's it affected the business? How has it affected the network infrastructure? I can just tell you from a consumer perspective, it's been completely invisible to me. I have not noticed at all.
That's one of the things I think we're looking at in conjunction with this. And one of the things we really want to focus on here is this is also going to tie into other areas. We obviously have areas of conjunction of regulation of social media. We're going to have, I think, in very few years, the regulation of, you have had these kind of things where it's what is something, what is under regulation. Other areas, just to give you an example of what this is, what is PayPal has actually
It used to be a bank. It started as a bank.
Yeah, it's so, and one of the big questions is it a bank or is it a money transfer service? That's one of the things that sort of bumped into, because those are regulated differently. Mm-hmm. Money transfer service, by the way, remember I mentioned Western Union and those money orders? That's a money transfer service, for one of the things that, so you bump into these real questions in conjunction with this major thing of regulation of a lot of what we see as the internet right now, when we're talking about regulation, has come into being without these regulations really be into place. These regulations were a start to try to put in some kind of regulation on top of what we saw there, which may or may not have, at the time they went in 2015 until their repeal, had that much of an effect on things. And then the question is, since their repeal, has that had a lot of effect on things? Where do we stand today in 2021 versus where we stood in 2014? Has the implementation, has the repeal had a lot of effect? What should we be doing as regulation? Should these be in place at all? And again, I think when Ben and I are looking at it in the position we have, we look at it and say there probably is some need for some regulation here.
I think I'd summarize it as when the net neutrality was really ramping up as a debate, it was before I went to law school, and I was in tech at the time, and it just struck me as a solution in search of a problem. I mean, I don't object to it. It sounds like a perfectly good idea, but we haven't had any of these rules so far. Why do we suddenly need them now? And I wasn't objecting to the rules so much as just not understanding the level of passion amongst the people who advocated for them. What am I missing, right? When the rules were passed, we just went through a couple of them. They all seem reasonable. They're all things that I don't want my ISP to do. I am fine with the FCC or anybody else telling them that they shouldn't do that. But my ISP, to my knowledge, at least wasn't doing that before. If they were doing it, I never noticed. So my consumer experience with net neutrality has not been commensurate with the degree of panic, I perceive out there about it. That's just one data point. If your experiences are different, let us know, because I'd really like to hear more about how this has affected different groups of people, different businesses.
Yeah, and I think that's sort of potentially a good way to sort of sum this thing up. And again, we tried to present that this episode is going to be sort of a discussion of history. When you look at it and you say, hey, I'm for net neutrality, I'm against net neutrality, what are you talking about in conjunction with net neutrality?
Yeah, start with that. Define the term. And then you can, I think it's like a lot of things, honestly. Once you define what we're actually talking about, you will remove a lot of disagreement right there, right? Because, when I see people say, I want net neutrality, and I look it up, I'm like, well, no, that doesn't make any sense. We can't do that. Well, no, that's not what I really want. What I really want is, and then they describe what's in those regulations. Like, okay, well, yeah, I'm on board with that. I think it really helps the conversation to start by getting down to the basics of, are we talking about the same thing or not?
And one of the reasons I think this has fascinated us, and we've said it in a number of episodes sort of previously, is to point out, and, as we've said in sort of the tagline of the show, asking interesting questions that don't necessarily have any answers. I think this is something where we have a very charged topic that a lot of people have opinions on, where there may not necessarily be a clear answer. And a lot of people look at it and say, there is a clear answer. The clear answer is this, because this is what I see the problem as being. But again, what the answer to it is, when we start looking back at the history of this, we have to realize that there's a lot of intermoving components here. There's a lot of different effects that these things have. And this is also a relatively recent issue.
Yeah.
These are complicated issues. They have a lot of moving parts. They have a lot of pieces to them.
Well, it's rare that we get to get into things like which regulatory agency is in charge of something. I think another reason we wanted to cover this topic now is there probably is going to be a window of opportunity for a new net neutrality regime going forward with the new administration. Whether they just go back to the 2015 order or do something new, who knows? But I think Kirk and I were talking right before we got on the call. I think this debate, which has been kind of quiet for the last few years, is going to ramp up in the next 12 to 18 months. And I think we're going to be revisiting this issue. So, I think we should all be thinking about that, though. Like, what do we want our net neutrality policies to be? Maybe the 2015 order didn't go far enough in your mind. It needs to be more aggressive.
What I think we are starting to see now, particularly in conjunction with social media, is the concept of content regulation. Mm-hmm. Should these rules have something to do with what the content of the thing is?
Which also, I think these rules are probably going to come back and be more important than ever. And I think it's worth taking a fresh look at them.
And I think I very much agree with Ben. I think we are going to see increased interest in this area, but I think we're going to see increased interest in this area, not just from the concept of net neutrality, but actually coming at it from net non-neutrality. And that's the way I'm going to put it. We should not be treating absolutely everything equal. We should have some kind of regulation. Now, the concern with that is who gets to decide what's unequal and what is our position.
Is the FTC the best body to do that? I mean, if they're not, I'm not sure who is.
But again, those are the kind of questions I think we're going to get into. We may very well revisit this topic in the future.
I'm sure we will.
What happens? Yeah.
All right, folks. So I think we're going to put the can on that one. And as we have this debate going forward, stay informed. If I have anything to take away from this, do not take for truth the pat summaries you see, even in reputable tech media. I mean, and the tech media I read was uniformly one-sided in condemning the repeal. And although I'm generally sympathetic to that viewpoint, the reporting on it was not even attempting to be fair or objective or talk about it. So if you're getting news like that, you've really got to kind of dig into it deeper, especially if you're going to be involved in debating how this regulatory regime changes going forward, if it does. So, all right. Next topic. I don't know if we've decided yet. I did get on Facebook a reference from a friend of mine in Mexico, actually, an article on a bunch of video game patents. So I thought maybe we could go through some of those. See if any of those are worth talking about. But I haven't looked at the article yet, so I'm not sure what all is in there.
There's some big involvement right now over patent litigation having to do with stuff related to video games. If you guys are aware, the Blizzard.net suits and some of the other suits related to effectively these portals for video games. There's some stuff going on in there too.
So yeah, topic not sure yet, but we'll get it sorted out. I mean, we'll get some content out to you. We are also going to try to get back to our oft-stated but rarely hit target of getting out 2 episodes a month. If that means we have to do some rewind episodes and play some prior content, we will. I imagine at some point later this spring, we're going to talk about Google v. Oracle in detail. That case is probably going to have an opinion coming out in, what would you say, May, June, somewhere in there?
My guess is probably. Okay. It's probably going to be before the end of the session. I guess there won't be an end of session case, so it might be.
So check out our website at lggpodcast.com. It has links to our various platforms where you can download prior episodes. And you can get in touch with us on Twitter, Facebook, and by email. You can subscribe to this podcast on the platforms. If you give us a review, it will help new listeners find us, or at least that's what everybody who has a podcast says. Never actually investigated that myself, but I assume it's true. You can find me on Twitter at Benjamin Siders. You can find Kirk at KirkDMN. And that's all for today. We'll see you next time. Lauren, play us out.
The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by Lewis Rice LLC, its officers, directors, employees, agents, representatives, shareholders, and subsidiaries. None of the content should be considered legal advice. As always, consult a lawyer. This podcast was produced and recorded in St. Louis, Missouri.
I was just trying to find a copy of the repeal order that was issued in 2017. I checked the New York Times, The Verge, Reuters, CNET, CNBC, CNN, The Washington Post, The Guardian, U.S. News, Political, USA Today, Ars Technica, and Wired. And none of their stories covering this had an actual link to the order that was issued. The only site I found that did was NPR, which doesn't surprise me. All right, ready?
Let's rock.
All right, here we go. 3, 2, 1. And welcome back to A Lawyer's Guide to the Galaxy, the podcast.